Next two, we have Thomas Yeh and Mike Kalekini. Please state your name. You have 3 minutes to testify on each agenda item.
Thank you. Good afternoon, Mr. Chairman, members of the council. Thank you for the opportunity to testify on resolutions 58 and 59. While good-intentioned or well-intentioned, the proposed resolutions can, fail to consider the safety issues and the law surrounding the ordinance. It was adopted in 2012 after some 10 wells had already been drilled. Why did that happen? It was done in the political context of an election year. As addressed in our letter of 2 days ago, we pointed out that the ordinance is legally flawed, overbroad, and preempted by state law, both as to noise regulations as well as the authority to issue drilling permits in and of themselves. When we talk about home rule, what the council needs to understand is that the county's own planning commission issued GRP 2, which authorized the drilling activities that have been going on, both at nighttime and daytime. And that permit contains even more stringent standards than the noise standards that exist under DOH rules, all of which PGV has been in compliance with. So when we talk about the ability to regulate noise, which the essential purpose of that ordinance was, the fact is that Chapter 46, which is the rule relating to the county's authority to adopt regulations and ordinances, specifically provides, and this is 46-17 subparagraph 2, an ordinance shall not be effective to the extent that it is inconsistent with any noise rule adopted by the Department of Health, which, as we know, the Department of Health has already adopted rules on. So in the context of the ability of that ordinance to then regulate noise, it has no such authority. And the reason the ordinance is overbroad, because we're not only talking about the term drilling, but also drilling operations. Now, as we know, previously in 2012, DLNR, as well as the geothermal industry, as well as experts, and the agencies that regulate drilling, all said this is not a good idea. And this is not a good idea
You have 30 seconds.
Because of the safety issues that stopping drilling operations at nighttime presents. And Mike's going to talk about what that means if this ordinance really were to be fully effective and PGV were to fully comply. That's with respect to the issue of whether or not this resolution 58 should be complied with. With respect to resolution 59, that implicates even additional problems, because when this council back in 2005 adopted that ordinance, the clear intention, based on the discussion on the record, was that even though the law was unclear as to who it applied to, the state of intentions, even for those who voted in favor of that bill, was that that bill would not apply to PGV. And the reason for that was because of the doctrine of vested rights, based on the GRP, as well as the drilling permits that it has from DLNR that goes back well in time. So, having received legal advice from its corporation counsel, which I don't believe is going to be changed today, is it fair and wise for this council to even ask corporation counsel to file a lawsuit against PGV? And the reason I say that is because under Hawaii court rules, you file a lawsuit and you know that it's improper, you're now subject to attorney's fees and costs. Not only that, but the enforcing agency for this county, the planning department, through its planning director, has affirmed that that ordinance does not cover PGV's operations. And in reliance on that, PGV has not only done drilling, but it's also gone ahead, entered into contracts, ordered supplies, spent substantial sums of money to get to the point where it needs to drill very shortly. And so that's a concept of vested rights as well as equitable estoppel. So for a variety of reasons, filing a declaratory action against PGV is going to be very unwise. I think the council needs to follow the advice of its corporation counsel, not go that route, and respect that there are various safety issues that are implicated by the overbroad and flawed provisions of the ordinance. Thank you.
Thank you very much. Mr. Kalekini, please state your name, and you have 3 minutes to testify on each agenda item.
So, my name is Mike Kalekini. I'm employee of Puna Geothermal Venture Ormat Company. Chair Kanuha, Vice Chair Poindexter, council members, thank you for the opportunity to provide testimony on Resolution 58 and 59. Starting off on 58, what I'm about to share is what I have shared consistently with the community, with other regulators at the state level, and it's the same talking points that we shared in 2012 when Bill 292 was at the council level prior to becoming Ordinance 12-151, which is more commonly known as the nighttime drilling ban. First and foremost, our opposition, our greatest concern is the safety aspects of the drilling process itself. We believe that then council members had some discussions with technical experts in the drilling field, but that did not, but the bill is still passed. So even today, that has not changed. The drilling operation is sensitive such that there are certain times where different increases in the risk for safety will definitely be a part that needs to be adhered to. The loss of continuity in the drilling process, not knowing what's going on at night during the 12 hours that a drilling developer would have to come out if you have to follow this ordinance, is potential for having an uncontrolled event, which has been referred to by several folks back in 1991. And based on that and detailed review of what happened back then, you know, these techniques for drilling and being safe have been reviewed and been successful. We've drilled 10 wells since 1991. You know, so safety is the #1 issue that I've shared since 2012 till today, and it continues to be our #1 concern. In fact, Ordinance 12-151 is really a bad ordinance if we're looking to ensure safety of our community, safety of the employees at the location. On 58, seconds. Thank you. On Ordinance 58, I would also like to go on record that I've also stated at community meetings that PGV will comply with every county, every state, every federal rule, regulation, ordinance. We will not willfully or blatantly disregard any rule or any law. And that's the same message I've shared at our community meetings. And you know, that's what I had for 59. Do we still have 30 seconds for 58?
Set your time.
Yeah, and real quickly, from the resolution that we see and for a lot of the testimony provided, you know, we are going above and beyond on the noise and the lighting mitigation, and we're going to increase our efforts on that. We realize that we're a nuisance. We also realize that we stay well below compliance levels, but we hear it loud and clear from the community that's not good enough. So we're going to make our extra efforts to reduce noise mitigation. We've got an acoustical engineer that came in prior to the project starting. Once we kick that off, we're going to have that acoustical engineer back and hopefully have some suggestions to further reduce noise and nuisance to the community. Thank you.
Thank you very much. I see a testifier, a young testifier in Kohala.